Thanks very much. In the context of what has recently happened with the Treasury and the Department of Justice and the setting up of the 1.8.
A federal judge threw out 9 criminal indictments, sanctioned a U.S. attorney for misconduct. 3 days later, the Senate confirmed him anyway, and nobody was told. What you just heard isn't a conspiracy theory. It's straight from the floor of the United States Senate. Senator Sheldon Whitehouse just exposed something extraordinary. A U.S. attorney, formally sanctioned by a federal court for serious misconduct, was quietly slipped into a mass confirmation vote without a single senator being warned. Indictments dismissed, grand juries tainted, a judge's scathing order buried. In the next few minutes, you're going to see exactly what happened, what the senator said on the record, and why this might be one of the most underreported judicial scandals of the year. Stay with me, because the timeline alone will tell you everything.
In the context of what has recently happened with the Treasury and the Department of Justice and the setting up of the $1.8 billion cop beaters slush fund, the very week after Police Week here in Washington, I thought that Mr. Schwartz's comments about the merit of standing indicated quite clearly why that self-dealing cop beaters slush fund is so deeply, deeply problematic, without even going to the Trump family tax amnesty that it provided with literally one lawyer's signature on the document. Usually, if there's a contested matter, there are two parties. In this case, one lawyer signed it. And we don't know whether he signed it as acting attorney general or as Trump's personal lawyer, but we do know that it created a $1 billion cop beaters slush fund, and we do know that it gave the Trump family and associated businesses amnesty from any tax mischief or fraud that they may have committed. And it's really hard to see how there was any real case or controversy in that little scheme. But I also want to note that Mr. Schwartz is here without blue slips from the senators from the Second Circuit state. And just to remind everybody, I warned when we got rid of the circuit court blue slip that this was going to be unpleasant, and I've had colleagues on the other side express their dissatisfaction when they were ignored for blue slips. So here we are again. I don't want to hear a lot of complaining about blue slips in the future after we go through these exercises and ignore senators' rights to have a blue slip. But I want to talk about something different that just happened fairly recently. In Wyoming, a U.S. attorney was sanctioned by the federal court. 9 criminal indictments were thrown out as a result of improper conversations with grand jurors by the U.S. attorney. He called the defendants murderers, even though there were not homicide charges in the proposed indictment. He called them bad guys, not run-of-the-mill criminals. He handed out his business cards to the grand jurors and invited them to get in touch with him privately. A 1L could do issue spotting in that fact pattern and see massive, massive error and misconduct. It was challenged by the lawyers for the defendants who said this is not an isolated lapse. It has metastasized into systemic institutional failure, and the taint is widespread and continuous. And guess what? The court agreed. The court said that the cumulative effect of many known instances of misconduct, implying that there may be further unknown instances of misconduct, justified dismissing the complaints. The court found that none of the U.S. attorney's excuses carry water when viewed, I'm quoting here, when viewed against the volume and the flagrancy of the misconduct, end quote. And then concluded that this U.S. attorney had abused his special position of trust. Here's what's interesting about that order and that U.S. attorney. That order was filed on May 15th of this year. 3 days later, on May 18th, that U.S. attorney who've been voted on in this committee was slipped into the big en bloc list for confirmation without anyone in the Senate being told about that May 15th order regarding his professional misconduct. And I gotta say, I don't think that's the way this committee should operate. I think if there's an order from the federal court challenging the integrity and the competence of a United States attorney who is pending before the United States Senate, and we're not informed about that order for 3 days, and we don't even get an individual vote on that nominee. Instead, he's buried into the en bloc group, which I think was 49 different confirmations that day. That's not what the Senate is supposed to be. This guy should not be a U.S. attorney. And his confirmation should certainly not have been slipped in without disclosure of this order into an en bloc confirmation vote. I think the Senate was misled by that, and my time has expired.
Let's strip this down to what actually happened. A sitting U.S. attorney, someone with the power to put people in federal prison, walked into a grand jury room and did the legal equivalent of putting his thumb on the scale. He labeled defendants murderers when they weren't charged with murder. He called them bad guys. He handed out business cards. That isn't an aggressive prosecutor. That is grand jury contamination, and the federal court called it exactly that. Systemic, flagrant, and an abuse of trust. Here's the detail almost every headline skipped. He wasn't just confirmed quickly, he was buried. 49 nominees were bundled into a single en bloc vote. Think about what that means. Senators voting on dozens of people at once. No individual debate, no individual vote. And tucked inside that bundle was a man a federal judge had just declared unfit. 3 days. That's all the gap there was between the sanction and the confirmation. 3 days of silence. Now zoom out. Every indictment that prosecutor touched is suddenly in legal jeopardy. Defense attorneys across his district are going to file motions. Convictions could be reopened, plea deals questioned. And beyond Wyoming, every U.S. attorney confirmed in that same en bloc bundle now carries a question mark. Because if this one slipped through, who else did? The damage isn't one judge, one courtroom, one state. It's a credibility wound on the entire federal prosecutorial system. Let me be direct with you. The blue slip tradition, the individual confirmation vote, the disclosure obligations to the Senate Judiciary Committee. These aren't bureaucratic rituals. They are the immune system of American justice. When you bypass them, you don't just confirm one bad nominee. You teach the institution that it can be bypassed. And once an institution learns that lesson, it does not forget. Senator Whitehouse isn't just complaining about procedure. He's diagnosing a structural failure. In real time, on the record. So here's what I want you to sit with. If a federal judge can sanction a U.S. attorney on a Thursday, and the U.S. Senate can confirm him on a Sunday, without a single senator being told, what does that say about who's actually being protected in Washington right now? Drop your honest answer in the comments. Was the Senate misled? Or did some of them know exactly what they were voting for? Subscribe if you want the follow-up, because I'm tracking every nominee in that en bloc list. This story is not over, not even close.